What is jual janji? Jual janji is a security transaction that was being practiced by early Malay society since 19th century, and as stated by Judith Sihombing in her book National Land Code, a commentary, jual janji evolved from a local community loan transaction where land is used as a security for the loan to secure full repayment of loan. In order to complete this transaction, the borrower will transfer his land to the lender with an undertaking given by the lender that the borrower can redeem the loan upon full settlement of the loan. It is also an understanding between the parties that the right to redeem stretched even after the expiry of stipulated time for repayment of the loan, because the transaction represented a communal assistance to those in need. This transaction is based on the Islamic concept of communal assistance, and any deed between two parties under Islamic concept should be based on the akad and intention of the parties during the formation of the contract. SK thus define jual janji as a conditional transfer with a right to repurchase. Maxwell wrote his report on Malay customary land tenure, published in 1884, interpreted jual janji as a dealing between the owner of a piece of the land who sells his property right of the land to the creditor, and upon full settlement of the loan, he shall be entitled to take back his land. If the term mentioned is not satisfied by the borrower, the sale will become absolute. Based on the first question, the first issue is whether all the transactions between Pumba and Kitty constitute a valid jual janji. Second issue, whether the amount that is required towards Kitty to pay back has an element of usury. Third issue, whether there are any exception under jual janji that may apply to Kitty. Last issue, whether Kitty has any right over the land after the default payment happened. There are 5 elements of jual janji. First, which is lender and borrower. Second, the existence of the loan. Third, the land as a security transaction. Fourth, land transferred to the lender. Fifth, if the borrower defaulted in repayment of the loan, land will be absolutely vested to the lender, or we call it jual putus. Jual janji also is capable of registration. The process involves the execution of 2 sets of Form 40A, prescribed stereotype statutory form in National Land Code 1965, to be used to register a transfer of ownership by the borrower as the transferor that has the effect of transferring the land to the lender. This form will have to be registered in the relevant land office. The second set of Form 40A will be executed by the lender as a transferor to retransfer the land to the borrower upon full and final settlement of the loan within the agreed duration. This form must be registered at the relevant land office in accordance with the National Land Code 1965. Requirement when borrower repays the loan within the agreement duration. However, if borrower default in payment, as agreed, lender can transfer the property to a prospective purchaser and recover his money. There are 2 exceptions of jual janji. First is time no more an essence, and second is the extension of time. Time is no more an essence is exception for the strict interpretation, which is even though court acknowledge that time is of the essence, but court would assist the borrower if the delay or non-payment of the loan caused by the lender himself. However, to use this exception, there must be acknowledged from the both party involved. Second exception is the extension of time, which is the lender grant an extension of time to the borrower impliedly or expressly, and the lender refused to accept payment, or it call it evading payment. In the case of Haji Abdul Rahman and Muhammad Hassan, a creditor lent a money to the debtor. Debtor transferred his land to the creditor with a collateral agreement between both of them, and the debtor repaid the creditor within 6 months. The land will be retransferred. Borrower failed to repay the loan on the time, but eventually managed to settle the outstanding balance and insisted upon the retransfer of the land. The court held that the collateral agreement to retransfer is only effective in contract. Thus, the repayment after the expiry of the contractual period cannot be allowed. Second case is case of Wong Si Ling and Saraswati Amal. The borrower failed to repay within the agreed duration, argued that there is a right to redeem. The court held that it was held the jual janji is a contractual transaction. As such, once the stipulated time has expired, the court has no power to extend the time. In the case of Tengku Zahara and Cik Yusof, Judge Brains refused to recognize a transaction as jual janji because interest was charged on the loan. This was not a transaction regularly carried out in accordance with the provision of a law relating to jual janji, but was substantially irregular and in contravention of those provisions in a number of ways. The whole purpose of jual janji is to provide a procedure of securing loans without infringing prohibition of usury. An agreement the transferee will let transferor remain in possession in consideration of a rent is not offensive of Muslim view, however would not justify capitalization of rent. In the case of Ismail Haji Embong and Lau Kon Han, the court held that the act of parties in entering into a second agreement after the expiry of the first agreement means the time is no longer of essence, and the transfer of the land to defendant was merely a conditional transfer and not an outright sale. Regarding the question given, the transaction between Pumba and Kitty constituted a valid jual janji. All the elements of jual janji have been fulfilled, which means there is a Pumba as a lender and a Kitty as the borrower. The law stated in the situation is 20,000, and the land security, which is Kitty's land in Kelang, will be the security for the transaction. The land in Kelang will be transferred to Pumba if Kitty fails to pay the loan within a specific time, which also indicates there is a valid jual janji between both of them. Pumba also promised that he would retransfer the land back to Kitty once Kitty succeeded in paying all of the loan. The collateral agreement between Pumba and Kitty indicates that the jual janji will be valid for 12 months from the date of 5th January 2020. That means Kitty may only get her land back in Kelang if she settles all the loan payments within those 12 months until 5th January 2021. The collateral agreement between Pumba and Kitty over time is an asset, as stated in the case of Haji Abdul Rahman and Muhammad Hassan, and also in the case of Wong Si Ling and Si Saraswati Amal. The court used the strict interpretation of the jual janji transaction, which is that time is an asset and there is no more extension. Once it has expired, the lender may take full possession of the land. By looking at the amount of the loan in the situation between Pumba and Kitty, the actual amount is 20,000, but it increases to 205,000. There is an element of usury. Hence, usury was prohibited in jual janji transaction, as stated in the case of Tengku Zahara and Cik Yusof. Advice for Kitty: when she wants to pay the loan, just use the actual amount that has been stated in the collateral agreement that has been agreed by both of them, which is only to 20,000. The third issue is that since there is an issue of extension of time between Pumba and Kitty, it may fall under one of the exceptions, which that time is no longer an essence, and the extension of time may be valid if both parties impliedly or expressly agreed about it. Again, the actual date for Kitty to pay back the loan to Pumba is until 5th January 2021. Looking through all the facts in the question, impliedly, even Kitty did not ask for an extension of the time at first, but Pumba's action indicates that he already gave an extension to Kitty, which that the loan actually need to be paid before 5th January 2021, but on 23rd December 2021, Pumba still reminded Kitty to pay the loan. That means there is a 12 months extension given to Kitty impliedly by Pumba's action. If Kitty wants an extra extension, she shall ask for it within 12 months and not after. As stated in the case of Ismail Haji Embong and Lau Kong Han, the court held that the act of party entering into a second agreement after the expiry of the first agreement meant the time was no longer an essence. Until the end of the year, Kitty still has the duty to pay the loan, even though there are so many months of extension impliedly given to her. Hence, with all the consideration given to the extension of time given by Pumba to Kitty to settle the loan, Kitty still cannot pay it, and in the end, the land in Kelang was totally in the possession of Pumba. Lastly, Kitty has no right to the land in Kelang since she failed to pay the loan to Pumba within the period of time. After being given ample time to settle it, she still can't manage to do it. Hence, it indicates that jual janji at first will be moved to jual putus, which means that the land in Kelang that was initially a security for Kitty to secure the loan will be fully under the possession of Pumba since she did not manage to pay the loan. To conclude, Kitty has been given so much extension of time by Pumba to pay the loan but still failed to do that, and the land in Kelang will be automatically be transferred to Pumba since the agreement stated that only once Kitty managed to pay all the loan payments will the land be retransferred. Hence, Kitty has no right over the land and jual putus has already come into force.
For the second question, there are 4 issues. First issue is whether the jual janji agreement between Mr. Morty and Farmer was valid. The second issue is whether the sales and purchase agreement between Mr. Morty and Dory was valid. Third issue is whether the farmer can redeem his land from Mr. Morty. And the fourth issue is whether Dory can recover her 10% deposit from Mr. Morty. There are 5 elements for a valid jual janji agreement. Firstly, there must be a loan transaction. The lender must loan the borrower a sum of money that is to be paid back within a specific time period. In this situation, Mr. Morty had loaned Farmer 15,000 ringgit Malaysia, which was received by Radi. Radi, in this case, presumed to be the registered co-proprietor of the land. Thus, the first element is fulfilled. For the second element is that there must be a lender. Here, the lender is Mr. Morty, as he, being a local loan lender, had loaned 15,000 ringgit Malaysia to Farmer. Thus, the second element is also fulfilled. Move to the third element is that there must be a borrower who is the registered proprietor of the land. Here, in this situation, Farmer is the borrower as he had borrowed 15,000 ringgit Malaysia from Mr. Morty. Thus, the third element is fulfilled. The fourth element is that there must be land belonging to the proprietor to be used as a security. The land in Shah Alam was agreed by Farmer and Mr. Morty to be used as a security for the loan. This is evident by the execution of a memorandum of transfer via Form 14A, which was later registered at the Shah Alam Land Office, thus transferring ownership of the land from him to Mr. Morty. The fourth element is also fulfilled. Lastly, for the fifth element, there must be a collateral agreement. In the situation given, Farmer and Mr. Morty executed and stamped a collateral agreement whereby Mr. Morty promised to retransfer Farmer's land upon payment of the 50,000 ringgit Malaysia to Mr. Morty within 24 months from the date of registration of the Memorandum of Transfer. For example, on 3rd January 2021. Thus, the fifth element is also fulfilled.
The situation given is a strict interpretation, specifically whether time is the essence of the contract. If the time is indeed the essence of the contract, the transfer of land and the collateral agreement will be regarded as a contract of sale, not a security transaction. In Haji Abdul Rahman and Muhammad Hassan, the borrower repaid the loan after the agreed time and insisted on the retransfer of the land. The court held that time was of essence, thus it was a contract of sale. If the parties had intended to create a security transaction, it must be a charge or lien. But since it is a contract of sale, repayment after expiry causes the borrower to lose his contractual right over the land. The land will then belong to the lender. Until this happens, the lender must uphold his part of the contract by not engaging in any dealings with the land. For example, the lender cannot sell the land to a third party before the expiry period. In Muhammad Isa and Haji Ibrahim, the lender sold the land to the purchaser before the expiry period. The purchaser knew about the jual janji agreement prior to the transaction, thus fraud was proved in the lender and purchaser. The transaction of the land by the lender was void and the borrower could redeem his land. Also in Husaini Yaqub and Tan Teo Siang, if the purchaser was a bona fide purchaser, the borrower may claim for the purchase price of land from the lender. Also, under Section 17C of the Contracts Act, a person is considered to have committed fraud if he had no intention to perform the promise after the promise was made. In Datuk Jaginda Singh and Tara Rajaratnam, fraud was found as the defendant did not have any intention to perform their promises stipulated in the contract. Consequently, Section 65 provides that the party rescinding the voidable contract to restore any benefits received from the other party. Farmer needs to pay the 15,000 ringgit within 24 months from the 3rd of January 2021 before he can redeem his land from Mr. Murthy. Here, time is of essence. When time is of essence, the jual janji agreement is a contract of sale as per Haji Abdul Rahman and Muhammad Hassan. Failure to pay means that Farmer loses his contractual rights over the land and Mr. Murthy would be the owner of the land. But within the 24 months, Mr. Murthy entered into a sales and purchase agreement with Dori to sell the land. Mr. Murthy thereby breached the contract with Farmer. Similar to Muhammad Isa and Haji Ibrahim, he had only entered into the jual janji agreement with Farmer to sell it to Dori, thus committing fraud. Similar to Datuk Jaginda Singh and Tara Rajaratnam, Mr. Murthy did not have any intention to keep his promise of retransferring the land to Farmer upon payment of the 15,000 ringgit, as he had immediately sold the land to Dori after he received the IDT from the land office. The SPA of the land to Dori was thus void and Farmer could redeem his land. Dori, on the other hand, was a bona fide purchaser, not knowing of the jual janji agreement on the land he had bought. Hence, he did not commit any fraud. Subsequently, as per Husaini Yaqub and Tan Teo Siang, Farmer may claim for the purchase price of the land from Mr. Murthy. Dori must also return any advantages he had received under the sales and purchase agreement, that is, the land, but he may also claim for any advantages he had provided under the contract, that is, the 10% of deposit to Mr. Murthy. In conclusion, the jual janji agreement between Mr. Murthy and Farmer was valid as it had fulfilled all 5 elements of a jual janji agreement. But the sales and purchase agreement between Mr. Murthy and Dori was void, as per Muhammad Isa and Haji Ibrahim, since Mr. Murthy had entered into it via fraud to Farmer. Thus, Farmer can redeem his land or recover the purchase price of the land from Mr. Murthy as decided in Muhammad Isa and Haji Ibrahim and Husaini Yaqub and Tan Teo Siang. Dori may also recover his 10% deposit from Mr. Murthy.